Module 8 specifically talks about practical drafting session in reference to filing of statement of claim, drafting of statement of claim, statement of defense, the arbitration invocation notice. These are again very important and critical aspect when it comes to drafting because each and every word of the draft matters a lot when it comes to fighting before the authorities and fighting for the dispute. Hence, drafting a section 21 notice or drafting the statement of claims, drafting of statement of defense is again very crucial and important for the parties. So now let us first discuss as to the important criterias when it comes to invocation notice. So section 21 of the Arbitration Act talks about invocation of notice for arbitration. Again, this is a very mandatory steps which is required to be complied with. For example, there are various statutes which provides compulsory issuance of notice before to the opposite parties to initiate the legal proceedings. For example, Section 138 of Negotiable Instrument Act, once the check is dishonored, it is important and mandatory for the parties to issue legal notice. In case of insolvency and bankruptcy code as well, when Section 9 applications are filed, it is important for the parties to send a demand notice for recovery. Similarly, to invoke arbitration, the concerned party is required to first issue a notice, that is the arbitration invocation notice, which triggers the arbitration. So again, a very mandatory step in case when you want to initiate arbitration. Now, what should be the content of the notice? The very first thing is names and addresses of the parties, reference to the arbitration agreement clause within the contract details. Again, very important. The specific clause to which or on the basis of which arbitration is invoked should be specifically mentioned in the notice. Brief description of the dispute, that is the recovery amount, the relief which you are looking for, that is again very important. Nomination of the arbitrator. Again, if the clause provides for a procedure, then that procedure should be followed. In case if the procedure is not being specifically mentioned, it is important for the parties to nominate the arbitrator. This is again very important. Calling upon the other party to concur in the appointment or nominate their arbitrator within a period of 30 days. So 30 days time is given to the opposite party to reply to the notice, either confirming the appointment of the nominated arbitrator or suggesting any other name. Now, serving the notice is again very important because the notice is required to be served through registered post, speed post, email if permitted, or as per the institutional rules. Again, very important. In case, as I told you in section 11 application, the high courts, in case if the parties fail to mutually appoint the arbitrator, the other remedy which is available with the parties is to approach the high court under section 11 to appoint the arbitrator. In that case, this notice becomes a very important document for admission and adjudication of section 11. Without this notice, court will definitely not entertain any of the petition under section 11. So hence, this notice is again very important. The next is statement of claim. Now, statement of claim can be called as pleadings of the claimant. It is very important to understand that it is the duty of the claimant to bring each and every fact, each and every issue before the tribunal and in written form. That will help them to cover up things and that will help them to make their claim more stronger one. So, the very first heading is in the matter of arbitration under the Arbitration and Conciliation Act. That is the cause title which we can say with the names of the parties, that is claimant and respondent with along with their all the details. Jurisdiction, that is reference to the arbitration agreement and appointment of the tribunal. So maybe the in the left part of your first page where the cause title is mentioned. So first will come the cause title, second will come the party's name, thirdly the reference of the clause number based on which this dispute has arose. Then start the story, that is the background of the facts in a chronological manner. Cause of action, again very important. Specific breaches, defaults. It is advisable to bring each and every fact before the honorable authority. The reason for this is no evidence should be missed, no communication should be missed because all the facts are important and relevant for adjudication of dispute. So it is important for the claimant to bring each and everything before the tribunal. Now, legal basis on the basis of which the contract is breached, and what are the provisions wherein the respondent have failed to make the payment or have breached the contract. The reliefs those are sought, that is specific amount along with interest, pre-award, post-award, cost, declaratory reliefs, everything have to be specifically pleaded before the tribunal. It is not that whatever is not being claimed or prayed for will be granted. It is very important for the claimant to plead and ask for all types of reliefs and all the claims which they are entitled for. Now, it does not mean that the claimant will just add on things so that the claim amount is bigger and bigger. It is only the legible claim which is being outstanding along with the interest if there is any provision that is required to be claimed. Next is the list of documents which are important to be submitted along with the statement of claim, verification signed by the claimant or the authorized representative that is required to be followed. So this is a format and the manner in which a statement of claim is required to be filed. Now in this, claim part is very important because that is the ultimate relief that you are seeking for. So claim will have to be specifically justified. For example, if you are asking for 2 crore of the amount which is outstanding with the respondent, in that case, how that amount is required to be recovered, justify it. If there is a 18% interest clause, justify the clause. In case if there is a claim for loss of business, justify it. Whatever loss was incurred or any expenses were incurred because of the project or because of the respondent, because of the delay, everything has to be brought before the tribunal. Here, one important thing is there. Generally, the fees of the arbitrators are decided based on the amount of claim. So, it will depend upon the total claim based on which the arbitrators' fees are decided. So, for assessment of arbitrators' fees, amount of claim is again very important. The next is basic pleading format when it comes to statement of defense. Now, for statement of defense, denial, specific denial is very, very, very important. In case if they have any jurisdictional issues, those are again required to be addressed before the tribunal at the very initial stage. If there is any counterclaim, that is also required to be filed along with the statement of defense. All these things are very, very important. Now, in case if a rejoinder is required to be followed, then the claimant will file a rejoinder in response to the statement of defense. Now, this is again a procedural part. This is not very important when it comes to all the arbitration dispute because the procedure is ultimately decided by both the parties. So, both the parties will have a right to decide on the dispute, to decide the procedure also, and the arbitrator will confirm the same. It is important for the parties to keep the pleadings very factual and not argumentative because arguments are required to be specifically argued before the authorities when final arguments are specifically placed. Until the final arguments, everything have to be required to be specifically and to be very precise. Now, the views of the arbitrator has been both the parties file their respective statements, that is statement of claim and statement of defense, with the documents, and that those documents run into thousands of pages. So this becomes very bulky, very difficult for the arbitrator. So it is always advisable to keep your pleas and the pleadings very, very, very specific and very, very precise. This will actually help the arbitrator to understand the matter in a very quick manner. This does not mean that you will not put up the facts which are unnecessary or not necessary. Let the arbitrator decide it. It is your duty as a claimant to put up all the facts. It is the duty of the respondent or defendant to put up all the facts. But how much bulky it is required to be made, that is a different question altogether. Arbitrators are generally not happy with bulky documents. The reason for this is if those are necessary, then only those are required to be placed. If those are not necessary for adjudicating this dispute, then there is no need for such documents. This is again very important. Lastly, all monetary claims must be specifically provided along with the principal amount, interest rate, period, total, calculations. Everything have to be specifically written in the respective statements. So this is all about the basics of pleadings. In the next session, we'll discuss few other more aspects in reference to arbitration in detail. Thank you.